Good morning. Today, I just would like to take this opportunity to address a few words about my research and appropriate approach to the amendment of electronic transactions law in Thailand. Well, let's begin with the purposes of this research first. This research has two main purposes. First, to discover flaws and shortcomings in existing legislation, which is the Electronic Transactions Act 2001 of Thailand. For short, we would like to call this act the ETA. Secondly, to suggest appropriate and practical way in which the ETA should be amended. In order to understand this, perhaps we would like to give a background pertinent to this act first. The ETA has been enacted in 2001 along the line of the two model laws initiated by the United Nations Convention on International Trade Law, or UNCITRAL, in order to accommodate the use of electronic methods in making transactions in the new digital world. In the digital era, paper-based environment is more and more replaced by the paperless environment. In making transactions, we now use more and more electronic records, or we can call this one data messages. Among these technological advancements, the law provides legal recognition of data messages by treating data messages in the same way as paper-based documentation. In general transactions, this recognition is indeed known as the functional equivalent rule. The examples of the recognition of data messages are as follows. First, the ETA allows making contracts electronically and give those contracts the same legal effects as those given to contracts made in a paper form. In order to make contracts, offers and acceptances may now be made in the form of a data message, and whether contract is required by law to be, say, made in writing or supported by written evidence or be signed. When the contract is made in the form of a data message, that contract is going to be regarded as having been made in writing or having been supported by written evidence or having been signed, as in the case of the contracts being made in the paper form. To give an example, the Acts allow retention of documents in an electronic form where the law requires a business person to keep accounting documents for 5 years. Then such person may now keep them in the form of an electronic file. Instead, persons may keep documents in, say, the PDF file format. So this act seems to be great. This is a great value of this legislation. Although the ETA has a lot of benefits, there are two problems surrounding this act as well. First, the flaws or mistakes. And secondly, the lack of new modern concepts. About the flaw or mistakes, for despite apparent business value of the ETA, this legislation has a number of flaws or mistakes which indeed constitute unfortunate obstacles to the use of electronic methods in making transactions. With respect to the lack of new modern concepts, the ETA does not have some new modern concepts as recently developed at an international level. Therefore, these shortcomings trigger immediate need for this research. In particular, this research explores deficiencies and inadequacies of fundamental provisions of the ETA and attempts to suggest an appropriate approach to its amendment. In order to conduct this research, we resort to a comparative law method, comparing key provisions of the Thai ETA with provisions of the two Assoc model laws, i.e. model law on e-commerce 1996 and model law on electronic signatures 2001. We also look at the UN Convention on the use of electronic communications in international contracts 2005. We also look at the provision of law in Singapore and in Malaysia, i.e. the Electronic Transactions Act 2010 of Singapore and the E-commerce Act 2006 of Malaysia. About the findings, the research reveals two important findings. First, unfortunate flaws in the Act, and secondly, desirable legal requirements to be put forth in the Act. With respect to the flaws in the Act, it is found first that certain mistakes reside in the Act as approved by Parliament in 2001. Moreover, the ETA underwent amendment in 2008 by the Act number 2. It is found in this respect that rather than making the Act better, the Act number 2 puts the Act in a mess. The Act number 2 indeed has brought about another set of flaws which are even more serious as a result of the law drafters' misconceptions and lack of proper understanding of the law. With respect to desirable refinements to be put forth, more recent developments lead to enactment of new rules at an international level. These new rules are now contained in the UN Convention on the Use of Electronic Communications in International Contracts 2005. The ETA of Thailand does not, at the moment, address certain issues as addressed in the Convention. This includes the following issues. First, the issue concerning the legal status of advertisements placed through an information systems like websites. Secondly, the issue in relation to input errors made in electronic communications. And thirdly, the issue as to some new concepts of electronic signatures. Well, given the findings which I have addressed above, this research makes recommendations of two important matters. First, the removal of flaws, and secondly, the introduction of new modern concepts in response to global legal development. With respect to recommendations on removal of flaws, this research recommends amendment of the following provisions of the ETA, Section 8, Paragraph 1, which is provision recognizing a data message as writing or written evidence. Section 8, Paragraph 2, which is a provision dealing with payment of stamp duties by electronic means. Section 9, Paragraph 1, dealing with electronic signatures. Section 9, Paragraph 3, dealing with electronic seals. Section 10, Paragraph 4, the provision dealing with printouts of data messages. Section 12, 1, the provision allowing the retention of information in an electronic form. Section 12/1, the provision on digitization of paper documentation into data messages. Section 16(1), the provision on attribution of a data message. Section 23, Paragraph 1, which is the provision setting out the rule governing the time of receipt of a data message in a situation where the addressee has not designated any information system for receiving communications. And Section 26, which is the provision on secure electronic signatures which are presumed to be reliable. Now, with respect to recommendations on the introduction of new modern concepts globally developed, in order to respond to more refined legal concepts as embodied in the UN Convention on the Use of Electronic Communications in International Contracts 2005, some new provisions should be added to our ETA with a view to achieving greater legal value and generating benefits from electronic transactions in the modern world of e-commerce today. For example, a new provision addressing legal status of advertisements through an information system such as websites should be added, and also a new provision addressing input errors made in electronic communications should also be inserted into the Act. It is very much hoped that this research and all the recommendations made in this work will be very useful for the lawmaking of Thailand. In particular, given that the government is now proposing a law bill for amending the ETA, these recommendations will serve as practical guidance for those concerned in the consideration of the law bill. Well, let's keep our fingers crossed for the good and very bright future of these amending attempts. Thank you.